Okay, we are working on staying on time, which is a first for me. Um, it is my pleasure to introduce a man who needs no introduction, Michael Blatcher, who is a partner at Lieber Cassidy. He's located down here in Los Angeles, but I'm sure everybody throughout the state knows Michael, and he works with so many of our schools and helping them with their legal issues in the wonderful state of California. So without further ado, I'd like to introduce Michael to provide us with a bracing legal update.
All right. Well, thank you, Martha. I really appreciate it, and appreciate you allowing me to be here and to participate. I look forward to this, and so I'm very happy to be here. We have an hour and a half, and a lot to get through. A lot of things that I think are going to be of particular interest to business officers. But one thing, it's always so important for me is that you ask questions as we go along. Unfortunately, I can't see all of you, but we have a chat box, and I will be doing my best to look at the chat box, to answer questions, to get back to you. And I want you to know that I really do put a very high priority on making sure that I'm addressing the issues that you want to make sure that I address. And if things come up and you have questions that you ask them, and if you disagree or whatever it is, I really, really want to encourage you to ask questions. So here is the list of topics that we have. It is quite a long list. I'm going to tell you right now that on some issues, I'm going to go a little slower on, some I'll go a little faster on. I have some legislation at the end, which candidly, I suspect I won't get to or won't spend much time on it. But we have a legislative update where you can look at the legislation. You can, if you're part of a consortium, you can call in and ask questions about it. We have a lot of material on the website. So you're probably familiar with most of the legislation anyway. But I wanted to start by asking two questions about the agenda. The first question is, if there's anything that you don't see that you want to talk about. And the second question is, which is related, is there anything on this list that you don't see that you're surprised is not on the list, that you would expect to be on this list? Okay, it's a very shy group. No one's saying anything. I won't take that personally. Let me just focus in on that second question I asked. I mean, is there something that you think in April of 2021, after the year we've had, that we might be discussing? Okay, so I'm getting a lot of vaccinations.
That's right, yeah.
Yeah. Okay, AB 1313. Let me tell you, here's what's not on the list that you may be looking for is COVID or vaccinations. I didn't put it on the list on purpose. I didn't put it on the list because I think we've had a year of talking about COVID and talking about issues, and it may come up as we discuss it, but I didn't want this to be another COVID discussion, so I left it off on purpose. But I do want to share something with you that has been coming up a lot, and I think it's really worth spending a couple of minutes on. I see that in the chat, DEI. We could spend an hour and 45 minutes talking about DEI. I only got so much time, but it's a good point. Here's the one COVID issue I wanted to kind of set aside. I decided sort of last minute to talk about it, and that is vaccination of students. I've been getting a lot of questions about whether schools can vaccinate students, require that they're vaccinated for the fall, might be a better way to put it. So I wanted to mention a couple of things about it. First of all, if you're asking yourself the question, can we require vaccination of students? I want to just suggest, just put it out there for you to think about, that you're asking the wrong question. And the reason I say that is because I think the question for most schools, I know actually this is not true of every school, but for most schools, the question is really, what's the best way to ensure the most people are vaccinated? And requiring vaccinations is one way to do it, but there's other ways as well, encouraging it, right? Giving out prizes for it, things like that. And I say it only because I do think it's worth some thought. Because when you require vaccinations, there will be some percentage of your population who will not want to get it just because you're requiring it. Who will say that, you know, this is now a political issue and I'm not going to do it. So think about it. Requiring vaccinations, we'll talk about in a minute, may be right, but it's something to think about. In terms of whether students can be vaccinated, I'm hearing over and over again from schools, for very good reason, that colleges are requiring it. And well, can't we require it if colleges are requiring it? And I'm reading articles that says, well, businesses can require it. Why can't we require it of students? So there's a number of issues I want to bring up. I will tell you that I think it's very unclear whether schools can require students to be vaccinated. And here are some reasons why. First of all, with colleges and with businesses, that's truly voluntary. You don't have to go to college. You don't have to walk into a certain business. You may be thinking, well, you don't have to go to our school. But the truth is, K-12 education is compulsory in California. They do have to go to a school. And as a result, and I think very importantly, the California legislature has a list of vaccines that are required to attend school. COVID is not one of them. So this issue could be fixed overnight. The legislature added COVID to the vaccines that students have to get to go to school. But it hasn't done that, and candidly, I don't think that'll be required. The other things to keep in mind anyway is that with colleges, you're dealing with adults for the most part. And at K-12 schools, you're dealing with minors for the most part. That's a big difference. Unless you're a boarding school, which is significant, I think, you don't have the same sort of need as colleges, because they talk about their dorms and all these kids living together in tight spaces. And that, they say, is a compelling reason to require vaccines. I think that's different for K-12 schools other than boarding schools. The other thing, a couple other things real quick, I'll just put out there, is that, you know, you have to deal with this, and I don't know why I'm laughing like this, but you have to deal with the stress of parents. And telling parents that their kids have to get a vaccination, that by the way is not yet approved by the FDA for kids, where parents might have high anxiety about it. Most parents may be perfectly fine with it, but you're going to have some percentage of parents who are going to say, we're not comfortable about it, we think it's rushed, we don't know the long-term effect, we just don't want to do it. And I think taking a hard line, you know, it may have a negative effect on them. The last thing I wanted to mention is that I am aware that the UC system and the Cal State system have just said that when the vaccine is formally approved, they're going to require it. You know, there is and by the way, those other people may know, and I'd be interested to hear it. Those are the only California colleges that I've heard that are doing, that they're going to require vaccines. And there actually is a case involving the UC system, which says that because the UC system has the power of the state, it can require vaccines. That's not true of private K-12 schools. I don't know the laws of other states where colleges are doing this, but I want you to know that there is some risk. And I think right now there's just a lot of uncertainty. So I don't have an answer for you. I hope to have an answer for you one day, but for right now I don't. But this question has just been coming up so much, I thought it was worth addressing in the beginning. Any questions about that? All right. Well, I'm going to move on then for the first polling question. Hope I did this right. The polling question is your school planning to continue some form of online learning during the 2021-2022 school year. Come on, I'm sure you advocate for people to vote all the time. Schools, they have a very low percentage, kind of embarrassing. Come on. Okay, I mean, one more second. 77%, I think. Come on. Nobody? 78. Okay. 80%. So here are the results. Interesting to me. Not what I would have expected myself. So only 5 people, 7% said yes, there will be some form of online education next year. 39% said no. 54%, big chunk, haven't decided yet. Well, I think that's very interesting. I'll tell you that I think every school should be considering whether there's benefits in having some form of online learning continue. And by the way, for me, that's very broad. That could mean making tutors available online, having counseling sessions online. It could mean having special classes that you can't get, being able to hire teachers to bring somebody in who doesn't live by you. I think there are a lot of opportunities out there, and I really think it's important to give it some thought. But, you know, interestingly, I guess, I don't know why I was surprised when I think about it by the poll results, because the feedback I get generally is that we want to get back to having kids on campus and everything being in person. And I understand that. And yet I think there's some real opportunities that I'm afraid are being overlooked. Okay, so I don't know what I just did. All right, so let me, oops, sorry. I'm gonna move on to a case about tuition refunds, which ties in some way to the polling question that was just asked. So I presume most of you are aware of this to some degree, and that is that there have been a lot of class action lawsuits at colleges and universities seeking reimbursement for tuition. So you have to go back a year, maybe slightly over a year, when parents were signing enrollment agreements for next year, and then everything went online. And the argument is that, wait a minute, when we entered into the contract, obviously, the expectation was that everything would be live. That's what we were bargaining for. That's what we were paying for. That's not what we got. So we want some form of refund to make up, you know, for what we've lost by having everything online. I'll tell you that I did hear from a few schools over the past year that they knew there were some parents interested in the same thing. I heard from many schools about that, actually. I heard from a few schools that there were some attorneys maybe who were sniffing around and were you know, looking maybe for some kind of class action. I've not heard of a class action lawsuit involving private K-12 schools in California. It's of course possible that that would happen. The statute of limitations is 4 years, so it might happen. But what has been happening around the country is that these class actions generally are getting dismissed. There was one I heard about a week ago that was allowed to go forward for trial, but they're getting kicked out. And the reason they're getting kicked out is because there's nothing in the enrollment agreement, there's nothing in the handbooks that say you have a right to in-person education. And so without something saying that there's a right to in-person education, you know, there really is not a way to make this kind of claim. So the news has been good, at least so far. The other thing that's important to keep in mind is that in California, you can't bring a claim for what's called educational malpractice. In other words, that's just a fancy legal way of saying we're unhappy with the quality of the education we received. We wanted an in-person education. We think it would have been better. We only got it online. Wasn't what we wanted. We're suing. In California, you can't do that. That's been super helpful. So as of right now, these cases are going nowhere, which leads me to April 2021. I want to put out kind of a warning to all of you, which is that as you, I know you probably have kids back on campus and it's been happening for a while. And I just want to suggest that you're careful how you message that. What I've seen from a couple of schools is the message going to parents is not just, we're excited to have kids back on campus, we're really glad to be here and see them in person, we can't wait to, all be together again. The message has been, being on campus is so much better than online education. Online education was so hard. We know kids have learning loss. They've been suffering, but they're going to come back and we're going to do it. That's a potential recipe for liability, because you are making admissions, potentially. This is not a privileged conversation, so potentially, maybe, conceivably, allegedly, that they did not get as good an education, that there was a loss. And so I think you need to be very careful about that. All right, any questions about that? Still no. Okay. Antitrust. Antitrust is a very significant issue that in my mind is not discussed enough. It probably seems like something that only Google and Apple and I don't know, railroads or something have to think about, but it applies to schools as well. And if you're not aware, there was a joint statement put out by the Department of Justice and the Federal Trade Commission not too long after, I think it was in the fall, or it might have been earlier, saying that they're aware that the pandemic is putting pressure on businesses to address things like wages and benefits. And it was a reminder that the pandemic is no excuse to engage in that kind of conduct. And, private schools are not immune from antitrust law. And so if there are, and I know, frankly, Cal-ISBOA is very good at getting information about salaries and things and doing everything that they need to do to ensure there are no antitrust violations. But there's one of the great things about independent schools is they tend to be very collaborative. One of the bad things is there can be antitrust violations as a result. So if you're calling other schools and asking, what are you doing for salaries next year? What are you doing for benefits? What are you doing for tuition? We have parents demanding this. We all need to hold the line and not, give refunds or something like that. You need to be careful. I may have shared this with some or all of you before, but I belong to a listserv for college and university council. And several years ago, those listservs were subpoenaed because it's not privileged. So when you're on a listserv, I won't mention anyone in particular, you need to be careful about what you post and about what you ask, because conceivably that's discoverable, and it could be discoverable in an antitrust case, among other things. But some of the things that I've seen on these listservs make me think of antitrust. And so I wanted to mention it and say, I think you should be careful. Okay, I had a question. I don't think it went to everybody, but a question, very good question is, am I aware of any litigation about businesses failing to protect its customers or employees from COVID or other illnesses? Well, I am aware of cases in the past. Cal-OSHA, by the way, will sometimes step in if they feel there's safety issues, and it could be illnesses, could be other things. They can step in and make claims. I've seen that before, and I've actually seen that before with schools. By the way, I've also, maybe that's not exactly related to your question, but I can't remember now the disease, but it was like a measles outbreak or something in some schools, may not have been measles, where CDC and other people got involved. There wasn't litigation, but there was certainly government involvement. I'm not aware of COVID. For COVID, if somebody were to get COVID at work, which I hope would not be the case, if it were an employee, then their remedy would probably be limited to workers' comp. I think the greater risk has to do with students getting COVID because they're not bound by workers' comp. And so that can be an issue. So it's a little late now, I know, but when it comes to enrollment agreements or policies in the handbooks and things, you want to make sure that you're setting the standards at an appropriate level, and not saying things where you're over-promising what you're going to do to ensure that nobody is ever exposed to COVID in the hermetically sealed environment that we have here at the school. You just can't meet that standard. So that's a long way of saying I've not seen a particular case involving COVID or anything recently, but I know that is a concern of schools. Okay, any other questions about antitrust? Anything we've covered? All right, I hope you're drinking your coffee during this presentation and it's just kicking in now, so you're all going to get psyched up and ask me a lot of questions. All right, we have polling question number 2, which I'm going to post here. This is actually a very important polling question. Have you seen at least one of the Borat films? Now, interestingly enough, I'm not getting a very high rate of, I know people are embarrassed. Well, I've seen one of them. I didn't see the second one. I saw one. 83, all right, I think I'm gonna do another second. This is very interesting. I don't know what this says about this group, but it says something about this group. Half of the people have seen at least one, and half have not. Exactly. What are the chances of that? That is crazy. All right, well, that's fine. No judgment. I mean, I saw the first one. I didn't see the second one. Why am I asking you this question? Well, I'm asking you this question because, which is going to be a lead into the next case I'm going to talk about. I'm asking you this question because I heard a really interesting interview with Sacha Baron Cohen, who's a, if you don't know, he's the guy who plays Borat, on Fresh Air. Terry Gross, am I the only one? I think I just aged myself. It's on NPR. I like it. I listen to it when I'm driving. Anyway, they had an interview with him, and Terry Gross said to him something like, "How do you protect yourself from being sued? When you get people to say these really, embarrassing, sometimes horrible things, how do you protect yourself?" And his answer was, to me, fascinating and important, which is why I'm sharing it. His answer was that he has attorneys who have taught him over the years that waivers are really important. And by the way, I just want to pause on that for 1 second, because I hear a lot from schools that waivers aren't worth the paper they're written on. That's always the phrase that I hear. And I got to tell you, that is not my experience at all. Waivers are really important. And Sacha Baron Cohen and his attorneys think the same thing. So he said, we have to have really good waivers. And he said what his attorneys have also shared with him is that waivers are more enforceable when they can be easily understood. By the way, also really important point, also something I really agree with. And I'm sorry to say that I'm probably as guilty of it, or more so than others. But when some of you anyway think about lawyers and think about waivers or agreements, you may think of pages and pages of legalese. That's not the kind of waiver that we want, that anybody wants, and that I think really does a good job of protecting schools. Now, it's difficult. I will say it's very, very difficult. But I think he's absolutely right. When waivers are written simply so people can understand, and when they cover the kinds of risks that you have, which, by the way, again, it's a difficult issue. If we had more time, we could talk more about it. They're more protective. And so he was, and I haven't seen, this is the Borat film. I think there's only 2 Borat films, but the one I didn't see, there's a scene apparently with Rudy Giuliani in a hotel room, involving somebody who's pretending to be, I guess, a minor. Again, I haven't seen it. And she asked him, like, the follow-up question was about that specifically. And his response was that Rudy Giuliani got the waiver, and the waiver said that there were hidden cameras and that there were hidden microphones, and that's why they were able to film the scene and use it, because he knew those were the risks when he, whatever, again, I didn't see the film. So that's something to keep in mind. I'm mentioning it, I mean, I think it's interesting. You all have waivers, things like that. And yes, Sasha, I just saw that pop up. Sacha Baron Cohen should definitely come speak at the legal symposium in the fall. That would be amazing. I'm getting excited thinking about it. I actually, yeah, anyway, we'll come back to Sacha Baron Cohen. But, you know, he made really, really good points. It's really something to think about. So it leads me to this question, this case, which has to do with arbitration agreements. Here are the facts. The facts actually are not that difficult, but they're really important. There's a 16-year-old girl who went to work for Del Taco. And when she went to work for Del Taco, they had her sign an arbitration agreement. How did they have her sign it? She apparently went to a kiosk and she had to click to sign her name. She never got a copy of the arbitration agreement. Nobody ever explained to her what the arbitration agreement said. And there was really no opportunity for her to speak to people about it and ask questions or anything like that. So what happened was she turns 18. 4 months later, she brings suit against Del Taco. She sues them, hard to say, for sexual harassment and for wage and hour violations. Del Taco, in turn, says, hey, we have an arbitration agreement. You have to take it to arbitration. Now, there is an interesting technicality here, which is that she says, well, there's a state law, by the way, it's a California case, state law says, you know, once I turn 18, I can disaffirm, I can get out of the arbitration agreement. Don't panic, you know, for the schools, because it's different when parents sign things and things like that. So she tries to get out of it. And the court, you know, the court looks at it and says, look, she was 16. She didn't understand the significance of what she was signing. Nobody explained it to her. She never had that opportunity. She never even had a copy of it. She gets to disaffirm it. And so she was able to take the claims to court. We don't know how it turned out. That wasn't the issue in this case. But I think it's a really good reminder of the importance of making sure that all of your documents, your contracts, your waivers, arbitration agreements, by the way, your handbooks, your policies, are written in a way that people can understand. And that's not easy to do. It's really not, but it's worth the time, and I think something that should be done. So keep that in mind. I know I saw some questions come in. All right. People really like Sacha Baron Cohen. I do too. I think all the questions were about Sacha Baron Cohen, so I can't add anything to that. I could do Borat impressions, but that wouldn't. I think I would start laughing hysterically at myself, and then you would start laughing at me, laughing at myself, but it wouldn't really make good use of our time. Okay, I have a question. Do you suggest a written employee handbook? Yes. I feel like I'm missing something from the question though. It is important to have a written employee handbook. For signatures as opposed to online signatures. That is a great question. Okay, I'm going to say two things and then I have to move on, but I appreciate the question. You reminded me of two things. Okay, the first thing is just taking your original, which I understand how you didn't mean it this way, about having a written policy. it is very important. I'm dealing with a situation now, and I deal with situations like this from time to time, so I'm just going to throw it out there. It's a student disciplinary issue. Some of you may or may not be involved with those to one extent or another. And it turns out the school doesn't have a written policy on it. They just sort of by tradition do things. Well, there's been some turnover. So now there's some question about what exactly do we do? Why do we do this? What's the standard? What does it mean? And so I think having something in writing in that regard is really important. In terms of online signatures, I'm so happy you asked that question. I could spend an hour and a half talking just about online signatures. I won't, I think. But here's what I'll tell you. When online signatures first came out, the position the firm took was one of skepticism towards them. And I actually think that was the right thing to do, because there have been a number of lawsuits over the last few years about when electronic signatures are enforceable. And that's what could lead to an hour and a half conversation. I want you to know that there are federal laws and there are state laws about what's required for there to be a binding online signature. And it's incredibly important that you meet those requirements, especially, by the way, in something like an arbitration agreement, where there may be time limits. And if you're not able to get what's needed to run into a judge and force it into arbitration, you may be out of luck. So making sure you're meeting those requirements is important. I do know of one school which is able to handle all of this internally. It's just got the people and the know-how where it's confident, it's complying with everything internally. Otherwise, in my experience, schools contract with somebody like Blackbaud, or there's others, I'm forgetting the name, and assume that they do what's necessary to make sure you have a binding online signature. And I'm here to tell you, you should check, make sure, ask them, do you meet the requirements in California for binding online signatures? Because that's not always the case. And by the way, I'm not saying that's Blackbaud. I just don't remember exactly the company. The last thing I'll tell you, just to be super candid about it, is once in a while I still come across schools that their online signature is parent type your name. And that's not going to do it. It doesn't meet the legal requirements. So it's a great question. I appreciate it. Okay. What's the appropriate length of time to give employees and or families to review agreements, contracts, handbooks? You know what? Can you hold off on that question? We have another case coming up where I'm going to talk about that. It's actually the next case. So I'm going to pass that. But if you think I don't address it, call me on it. Totally fine. Okay, we print full handbooks every year for every employee, and it seems like a waste of paper. Seems like a waste of paper to me too. We have the handbook available online, but requires signed acknowledgement form. That's fine. I see that a lot. By the way, this next case you're all going to love. I can tell by the way these questions are going. We send an electronic copy of the handbook and an electronic signature. They can print the wish. Yeah, that's fine too. There's no one right way. I mean, I was going to say, there's no one right way, but I will say there are often many wrong ways. I don't even know if that makes sense. But what it means is, like, if you're going to get an electronic signature, make sure you're meeting the requirements. I don't care if you get a hard copy, an online copy, but make sure you're able to rely on it. Let me talk about this next case because I think it's actually relevant. Let's go the wrong way. So this is a case where the handbook, again, lots of questions about handbooks. 2017, all employees had to sign an acknowledgement, and I'm going to read what it said. I'm going to look down. I'm not ignoring you. I just want to make sure I'm reading it correctly. That when they sent out the handbook acknowledgements, it said, "It is my responsibility to read and familiarize myself with all provisions." Okay, I just wanted to read that to you because I really like it. I didn't write it, but I really like it because what I read a lot is it's so like I attest that I've read and familiar with the whole thing, and then people later say like, and nobody does that. Of course I didn't do it. But if somebody's saying like, I understand, basically it's my responsibility, well, that somebody could say they do, that you can hold them to. And so I like that language. So that's how this company, Hulu, you may have heard of it. I don't have to, but that's what they did. And that was in 2017, in January. In October of 2017, an employee, the employee at issue here, who, like all of our stories today, is going to decide to bring a lawsuit because I'm a lawyer. Those are the only stories that I read. And so he brought a claim of sexual harassment. In 2018, they sent I'm sorry, in November of 2017, that really matters. They sent a revised agreement. And they sent a revised agreement that had an arbitration clause. Now, here's something that's important and goes to many of the questions getting. They actually sent a copy of the arbitration agreement. And everybody had to sign an acknowledgement. I think that makes a lot of sense. Arbitration agreements are very important if you have one, and we could spend a lot of time talking about whether you should have them. There's pros and cons. I'm not here to tell you to have them, but I'm saying if you have them, then I think you want to know they're enforceable. And arbitration agreements are very highly litigated. I feel like a couple of times a week I'm reading about a case and arbitration agreements and whether it's enforceable. And so sending out an arbitration agreement so the person can have it, they can look at it, so they can ask questions about it, I think really makes a lot of sense. Now, Nicole had asked, I said I would answer it. How long do you have to give them? There's no law on that. It's, I think, a reasonable amount of time. One of the reasons I like the language that I read to you about it's their responsibility is you don't have to really worry about how much time. If they want to sit down and do it that night, fine. They want to do it over the weekend, great. If they want to spend a little longer, what do you care? So I kind of like that language. In terms of arbitration agreements, here it is. You can look at it. I don't know. I give them a few days to look at it, maybe a week. I don't know. But I appreciate the question because I think having some time, to consider it, to ask questions, to make sure that it's meaningful, in other words, is important. So here's what happened in this case, by the way. He brought suit for sexual harassment, and Hulu said, well, fine, but we're going to go to arbitration. The trial court said no arbitration because it's unfair in the middle of employment to send an arbitration agreement, and everything wasn't clear enough, and we're not going to hold them to it. What do I think is really going on there? Courts don't like arbitration agreements. That's my view. Courts want things in court. And there's been a lot of articles about it. You can read a lot of whatever. California Supreme Court has had to step in and overturn the California legislature when it comes to laws on restricting arbitration. There was a legislation last year that's been put on hold. So it's highly litigated. Hulu appealed, and the Court of Appeal overturned the court. And the Court of Appeal said, he got the notice. He was told to read it. And the fact that he said he didn't read it and he didn't have time, that's on him, right? That's not on the company. And you can kind of see why, right? That the law, I think, would take the position that you have to be given the opportunity to read something, the choice to agree. But you know what? If you don't read it at the end, nobody can make you. There's no law that says somebody has to sit down and read it to you. So they reversed the trial court. But I want to tell you, I think Hulu got lucky in this case. A lot of the cases I read, the courts and even the courts of appeal side with the employee for a lot of reasons. One of them is there's an imbalanced power, and I think that the courts sympathize with the employee. Our firm's position, which I think is, again, consider the source, take it for what you think it's worth. our firm's position is that when you have arbitration agreements, it should be a separately signed document. And it's because they're challenged so much that the issue of did the person have it? Did they have an opportunity to read it? Did they know what they were entering into? There's just no substitute for a separately signed agreement. Okay, I saw some questions pop up. Okay, so the last question, which I was just talking about, but I'm going to transfer it. Can we include arbitration in employment agreement, but not handbook? So I just want to clarify this. Safest thing, and what we recommend is that you have a separately signed agreement. Typically, it's attached to the employment agreement. I do think Hulu got lucky. There are cases that say that having arbitration language in an employee handbook is not sufficient. Here it was okay, but I think the process that Hulu went through to make sure the person was aware of it really went a long way. But I really highly recommend it for employees in particular. All right, any other questions? All right, criminal background checks. You know, I'm going to mention one thing only because for whatever reason, this issue has come up to me like 3 or 4 times in the last week. If you don't know, there's an education code. It's 44237. And what it says is that I'm summarizing, every school has to do a criminal background check on applicants before they're hired. So you don't have to do it on every applicant, but if it's somebody that you're going to hire before the person is hired, that's really important. You need to do the criminal background check. I just want to make sure you're aware of that. You can argue with me, by the way, because I get argued all the time about we can't do it before we hire them. We would lose them as a client. At the time, okay, fine, we can talk about that. But that's the law. And by the way, that's not the only background check you need to do. That's the criminal background check that's required by law. But if you're not also doing a background check where you're getting information on application, where you're calling supervisors, where you're finding out information about it, you know, you may be subjecting yourself to a negligent hiring claim. Okay, I saw a question just pop up. Must a person be informed what they are signing? Be given time to review it, be given the opportunity to decline, especially if there's a language barrier. Okay, I don't totally understand the context. If they're being asked to sign it, then I presume they would know what they're signing because they would see it, I think, to one degree or another. Oh, arbitration agreement, okay. So, would they be informed of what they're signing? Yes. I'm just going to go through very quickly. Must they be informed? Yeah, they have to know it's an arbitration agreement. If I'm missing something, you can let me know. Do they have to be given time to review it? Yes. How much time? I think that was Nicole's question. There's no law on that, but you'd want to make sure that it's reasonable, in my view. And do they have to be given an opportunity to decline? That is a great, that's my favorite part of your question. Although it's all good, that's my favorite. I'm allowed to play favorites. Here's the thing, I would say yes. They have to be allowed to decline. But if they decline, then they don't have to work there. In other words, I could read your question at least 2 different ways. One is, do they have to be allowed to decline but still be offered the job? My answer to that is no. But do they have to be allowed to decline and then not work there? Yeah. So you might say, hey, congratulations, you know, we'd like to hire you. Here's the arbitration agreement you have to sign. If they say, well, I don't believe in arbitration, you say, I totally understand, I respect that. Goodbye. If that's a position you want to take, you totally can. So nothing that is not illegal. And by the way, I will say too, just for whatever it's worth, when it comes to arbitration agreements, if you were to make exceptions, wait, you don't want to sign, fine, you do, you're okay with it, I think that could cause a lot of internal dissension, maybe some morale issues, things like that. With somebody in one room signing an arbitration, somebody in another room not. I don't think that's a good idea. Okay, if an employee asks for a copy of their DOJ background check, are you supposed to give it to them or not? You know, I'd have to double check that. If the DOJ background check is the reason they're not hired, you do have to give them a copy of it. If they are hired, I don't know. I would want to check and be sure because the law is very specific and very restrictive on that point. So I'd have to look. If you want to look, I think it's under 44237. It might also be Penal Code 11105.3. Okay. Let me talk about this case, and then I see there's other questions coming in. So criminal background check, here's what happened. Somebody applies for, Tracy Molina is her name. She applies for a job at, I'm sorry, it's not Tracy Molina, but she applies for a job at Premier Automotive Sports. She gets hired, but when she fills out the background check, she doesn't mention that she had been convicted, by the way, convicted, not arrested, which you're not allowed to know, but convicted of grand theft auto. It might be a concern, you're thinking, wait a minute, she was convicted of grand theft auto, she's working for a place that's automotive imports. Is that a problem? Well, it turns out it's not a problem because that had been dismissed. And there's laws, you can see Labor Code 432.7, if you have a conviction that's been dismissed, there's another word for it too, which I can never think of, you don't have to put it down. So she gets hired. And she's working there for a month. And by the way, by all accounts, she's doing a great job, hasn't driven off in any cars. And she has to get also a DMV background check. DMV does a background check, reports to Premier, wait a minute, she has grand theft auto on her record. What does Premier do? They fire her. And she says, wait a minute, I don't have to report it. It was dismissed. And she said, you should rehire me. They don't. This case, the litigation goes on for a long time. I won't get into the details of it just because we're short on time. But the court ultimately rules for the employee and requires that she be rehired, plus there's penalties and things like that. What the court says, and I think this is really an important point I want to make sure you're aware of, the court says that as soon as the employer learned that there was a discrepancy, its duty was to investigate it. It did not have the right just to rely on what the DMV said and terminate her. It had an obligation to investigate on its own. The DMV, by the way, partway through the litigation, realized it made a mistake and corrected it. Said, we made a mistake. You should rehire her. We were wrong. And they still refused to rehire her. So, it's one of these cases that I really love because it demonstrates, I think, the importance of process, right? The law is not just about, do you have the conviction, do you have not have the conviction? What does it say? Here, the court is saying that, you know what, had you looked into this, if you talked to the DMV, spoken to the employee, you could have figured this out. And the court really spent some time talking about that. Okay. Okay, I had a question. Does a new hire have to sign that they read the handbook? Well, we talked a little bit about whether to say it was read. I'm not a fan of that. When it's not provided until after they are hired and have access to said handbook. Okay, I'm going to answer this quickly. You can always follow up with me if you like. It's better for the employee to, have access to it soon. I don't know why they'd have to have it before they're hired exactly, but it's certainly a good idea to have some kind of orientation program, intake program where you would go over handbook, important policy, and things like that. So if you have other questions about that, let me know. I'd be happy to talk to you about it. Okay, another polling question. Polling question number 3. Does not involve Sacha Baron Cohen, unfortunately. Do you have any independent contractors working for the school? We'll wait a second for you to respond. Well, embarrassing low turnout. I'll give you another second to respond. No. Yeah. All right. Here's the results. 82% say yes. That's higher than I would have expected. 15% say no, and 3% are unsure. So independent contractors, if you don't know, that is a significant issue for independent schools. There's been developments in the law the last couple of years. I'm here to talk to you about the latest development. You may know that in 2018, there was a California Supreme Court decision called Dynamex, which set out a completely new test to determine whether somebody is an independent contractor. I will say, just for whatever it's worth, my sense is that maybe 10 years ago, 20 years ago, if you had somebody, you just kind of didn't want them to be an employee, you weren't sure what to do with them, you called them an independent contractor, and there were lots of people working as independent contractors. That's, just how they were classified. That's it was changing before Dynamex, but after Dynamex, it really needed to change because California Supreme Court set out a new case called the ABC test. I'm just going to tell you what it is super quickly in case you're not aware of it. It's a three-part ABC test. A is that the person working as an independent contractor has to be free from the control and direction of the school. B is that whatever the independent contractor is doing has to be outside the usual course of what the school does. And C is that the independent contractor has to be sort of on their own, engaged in whatever it is that they're doing for this school. The example that the California Supreme Court gave as to what would definitely qualify as an independent contractor would be a retail establishment that has a plumber come to fix the toilet. That should give you an idea of just how far away from what the employer is engaged in, the independent contractor has to be. Okay, I'm not sure that independent schools hiring independent contractors meet that test. We get more and more questions about this. Again, there's pretty severe penalties and things for violating it. We could talk an hour and a half easily about coaches, about substitutes, about all kinds of things. But that's what you need to be focused on. You need to be even more focused about it now because this most recent decision from just January 2021 says that the California Supreme Court's decision is retroactive. So now people who worked for you 3 years ago, conceivably 4 years ago, could bring claims if they were misclassified. If they were misclassified, there's nothing you can do about it now, but you can stop it from happening in the future, and you should. So there was a high percentage of schools with independent contractors, and I really encourage you to think about this ABC test and to be sure, to be confident that you could meet it for your independent contractors. Okay, reduction in force. About a year ago, maybe a little more, I was in a lot of schools that were thinking about reduction in force. Thankfully, not so much now. But I did want to talk to you about this case. You may be dealing with reduction in force this year, next year, and I'll tell you a little bit about this case. So this employee worked for aerospace for quite a while. And aerospace lost out on a contract with the Department of Defense. They had to go through layoffs, and they had their own policy for determining who could be laid off. And I want to pause on this for 1 second because when I worked with schools, before on layoffs, but just last year was more than usual. And one of the things that came up a lot was, do you have a layoff policy? And I have to say approximately 100% of the schools did not have a layoff policy, which is understandable. But a layoff policy is something that you should consider. You could consider having it just to have it, or if you are going to be faced with a layoff somewhere down the line, you may want to adopt one, because having a layoff policy can really increase your discretion. It can really help protect you legally. So it's something that I want to put out there to make sure you're thinking about if you're faced with this situation. Aerospace had a layoff policy. They considered performance evaluations. They considered performance issues, like, had you been written up for something? They considered your skills, and they considered your areas of expertise when making the decision. So this employee was laid off based on that criteria. And I think what's really important, and I think you'll understand why it's so risky, is the person who took over his duties, in a sense, was 14 years younger than he was. That's typically not a good fact when you're dealing with layoff, when somebody older is being let go and somebody 14 years younger is taking over. In fact, there was a class action lawsuit against aerospace based on their layoff. And I want to tell you just what the claims were. The claims were harassment, discrimination, retaliation based on age, retaliation based on association with people in protected classes, violation of FMLA rights, national origin, and religious discrimination. And I got to tell you something. I see that a lot in complaints. In other words, people throw in everything that they can. And once you're faced with a lawsuit, one of the most important things is documentation. And you can't make that up after the fact. And so aerospace, fortunately, had done a really good job of documenting things before the layoff about the performance evaluations and the shortcomings and the skills and everything like that. So they were really well protected. One thing that I think for sure schools can work on, always makes me the most unpopular person in the room, but since I'm an attorney, I'm already the most unpopular person in the room. I will tell you that having better documentation, that's important. And getting procedures around it, making sure that your documentation is honest, that it's accurate, that it's being shared. Everybody should be working on that, in my view. Okay, I got another question I saw from Juana. Thank you, Juana. Michael, with COVID, we hired extra people, but we were clear that it was due to extra support due to COVID. But I still worry as we do not have a need to keep them employed for 2020. Okay, so so thank you, Juana. Let me restate the question, because I've had this come up a couple of times, and so I think it's worth just lingering on for a moment. I'm behind, and I want to catch up because there's important things to talk about. So what happened with COVID? Schools needed to hire more people. I think that's what you're telling me. I heard that from a lot of people. It just based on what was necessary to break kids into pods and have people that weren't going back and forth in between. I assume wanted something like that you needed. So yeah, so she said yes. So here's the thing. I think that, yeah, this is the time of year when you're going to have just a difficult conversation with those employees and say to them in a way that I certainly know you will, Juana, but I know that everybody on this call will too, in a respectful way that's, understanding you're giving them bad news, things that may be difficult for them to hear. I really feel for them. I really do, that, you appreciate what they've done for the school, that in planning for next year, you recognize that their position won't be needed. So you wanted to let them know now. If they have questions, they can go to Juana or whoever it is at your school. And I think that's the way to have that discussion. In a sense, it is a layoff. It's actually, in some ways, I think the perfect definition of a layoff. The legal definition of a layoff is getting rid of a position, not a person. So in other words, the distinction is if you were terminating somebody, you're getting rid of that person, presumably because of performance issues. If it's a layoff, you're getting rid of the position because it's not needed, even though they may be the greatest performing employee that you have. Okay, those employees will be hitting for unemployment soon, guaranteed. Yeah, that's true. And by the way, okay, so yes, so David said EDD is a complete mess these days. That's true. You get summary judgment, by the way, on that, David. You can't argue that point. And EDD and figuring out how people collect and when, again, we could spend an hour and a half on that too. Okay, if you're at will employment, do we need a layoff policy? Another great question. So I'm gonna just answer it quickly, but really, it's a wonderful question. Okay, if you don't know, but by the way, there's more confusion on this than you may think. At will means that you can separate somebody for any reason or no reason. By the way, that's usually the only part of the definition people know, so long as it's not discriminatory. Okay. In California, there's a labor code, it's 2922, which says that if you have a contract with a person, it either says for a month or more than a month. Can't remember. I think it's a month or more. The presumption is that it's not at will. So I appreciate the question, Jesse, because it's an opportunity for me to just say, I want to go back and look at your contracts. We get contracts a lot. I get a call from the school. We're definitely at will. 100% we're at will. I know we're at will. I say, well, do you have contracts? Yes, we have contracts. Really? Yeah, we hire them. 10 months. Whoa, somebody. Sorry, scared me. That we hire them for 10 months or 12 months. That's potentially a problem. Okay, that's my soapbox part of the answer. Even if the people are at will, you still may want a layoff policy, right? Because layoffs, for example, you might have different benefits you give with people who have layoffs. It may be another way of explaining the non-discriminatory reason for the decision. There's still a legal distinction between termination and layoff. So you may not, but I would definitely consider it. Okay, Julia asked, what if your contract specifies they are at will? So for many schools, there'll be a contract for a term, 10, 12 months. By the way, I think it should be 12 months. We'll talk about that some other time. But it says something along the lines of, despite the fact this is a contract for 12 months, it's the intent of the parties for it to be at will. I generally think that's fine. In other words, we're creating an at will contract. Why? Because the labor code says that there's a presumption that it's at will. If you have clear language, there's a presumption that it's not at will if it's for a month or more. If you have clear language in the contract that says this contract is at will, that overcomes the presumption. And I've had that come up. I've had push come to shove on that. So I'm pretty confident in saying you're in a good position. By the way, you're in a better position if you don't have it for a term. If I were running every school in the world, besides the fact that I'll be a disaster because I'm not an educator, all of my contracts would just say, congratulations, you're hired as of this date. See the employee handbook for details. Everybody would be at will. Anyway, all right, I'm going to continue. Wage and hour cases. We could talk about wage and hour not only for an hour and a half, but for a day and a half. Still not cover everything. But I'm just going to tell you what I love about this case because I'm behind. The facts are very simple. There were people who worked overtime. There was a sort of a low-level employee at this company who was told by another relatively low-level employee, you know what? Don't pay them overtime. Don't do it. Just pay them straight time. And this employee said, okay. Didn't pay them overtime. What happened? The Department of Labor actually took up the case, which is never a good sign. If the Department of Labor shows up saying they're representing an employee and they're suing you, take it seriously. So it's truly making a federal case out of it. So there was a lawsuit. And there, by the way, was no doubt that people wrote overtime, they weren't paid. The defense that this employer tried to use was that basically we can't be held accountable. This was a low-level employee who made the decision. That was just thrown out immediately. There was sort of a lot of scoffing going on. And of course, the company could be held liable for what one of its employees does. I think this case is so important because it really highlights two things to me. One is the importance of making sure all of your employees are well trained. Your employees need to know that if somebody works overtime, they need to be paid overtime. And that needs to be absolutely clear to them. It also needs to be made clear that if somebody tells you to violate the law or violate your own policies, that needs to be reported. That's something that's really important. I don't know anything about this company, but I think those are two really important lessons to take from this case. Okay, public accommodations. This is a case that I'm sort of surprised I don't see more often, or cases like this. So I just wanted to sort of put it on your radar. This was a case where someone was a member of a credit union, and he was blind, but he had a machine that allowed him to read the website so that he could navigate it. And the website wasn't created in such a way so that he could use the website with his device that allowed him to sort of be read to him what was on the website. And so he sued under the Americans with Disabilities Act. And I just want to mention, as kind of a side note, that he sued under Title III of the Americans with Disabilities Act, which may mean nothing to you. But Title III is the same part of the ADA, which says you have to reasonably accommodate students. And schools are specifically defined in the ADA as places of public accommodation. So in other words, this law applies to you just like it applies to a credit union. The case is an interesting one because the court had to figure out whether websites were covered. The ADA was created in 1990, and guess what? How many of you were surfing the web in 1990? None of you were surfing the web in 1990. By the way, if you tell any of your students that you were alive before the web, they won't believe you, but that's another story. Anyway, the court had to try to figure out, are websites covered? There wasn't even websites in 1990. How could the law cover websites when they didn't exist? But through a couple of different ways of getting at it, they decided it did cover websites. So if you haven't discussed with whoever creates your websites, whether they're ADA compliant, now's a good time to do it. I am surprised I haven't seen more of these kinds of cases because there are organizations who sue on behalf of the disabled. And it's important to have those kinds of organizations. And I would expect to see more of these cases than I have. Okay, new polling question. Oops, sorry, I gotta forward this, yes. Does your school plan to have overnight trips next year? I'm going to give you a few more seconds to answer. Remember how important it is to vote. Maybe next time I'll have stickers to give to people who vote. Okay, I'm going to end polling, share the results. So it's interesting. 56% said yes, you're planning to have overnight trips next year. I take that as a sign of real optimism. Only 5% said no, and then a big chunk of people, 39%, said maybe. So we'll see. I'm feeling optimistic about it, but we will see. But I mention it because that issue is important, and I'll tell you why when we talk about this case. So here's a case involving negligence, and I'm just gonna talk to you for a minute about this case. I'll see if anybody's willing to answer my questions in the chat. This is a case, it's 2013, kids go away to college for the first time. They go in the fall, they're living in the dorms, it's Halloween, they're going to a party. Guess what they do in the dorm before going out to the Halloween party? None of your students would ever do this, none of your kids would ever do this. But what do other kids do when they go away to college for the first time? Living in the dorms, going out to a party. They drink, yes. Thank you, okay, thank you, 3 people, yes. So these 2 students did just that, they drank. They went to the party. I'll just give it away. They drank. And they drank in excess, by the way, and it's not a good thing. They went back to the dorms. and they had to check in with an RA. Now, by the way, I should mention, when we were at the Halloween party, their RAs, the resident assistants, the people in charge of overseeing them, were at the party. They didn't give them alcohol, but they were aware they were drinking. They went back to the dorms. They had to check in with the RA. The RA could see that one of them was drunk to the point she was having trouble walking. It was a man and a woman, by the way. They went back to the dorm room. Anybody want to guess what happened next? It's a sad situation. We see this a lot with cases. Yes, they had sex. And the claim the next day was that it was not consensual sex. Okay, that's basically the facts. Super unfortunate. Unfortunately not so uncommon. Those are the facts. Here's what else is not uncommon. Who got sued? The university got sued. You may be thinking, why did the university get sued? Or in your case, why did the school get sued? And I see these cases where the schools get sued too. Why? Because the student making the claim said you had an obligation to protect me. You knew that college freshmen living in the dorms on Halloween would drink. In fact, the RAs, who are the ones who sort of oversee us, saw that we were drunk. They should have protected me. They should have stopped me. We see these kinds of claims a lot. So there was a lawsuit, and the court, well, you can see, the court said, yes, there is an obligation to protect students. And I just want to pause on that for one second, because when your students start traveling again, when they start taking overnight trips, if you start going on international trips, if you start sending kids to go live with other families and other places, you have a duty to protect them. You have to make sure you're meeting the standard of care so that you're not found negligent. And we see these cases. These cases do come up. And if you're ever asked, well, on these overnight trips, what did you do to ensure the kids were going to be safe? If they were staying with other people, what did you do to ensure that these families were ones where the kids were going to be safe staying and things like that? You don't want your answer to be nothing. So the court found that there was an obligation. By the way, there was a case from last year involving UCLA that came to the same kind of conclusion. So we know that there's these kinds of obligations. In this specific case, though, the university was able to prevail. But I think the important thing to know is that there was a duty to protect, and that same duty applies to you. All right. I'm going to talk about disability interactive process. I'm going to go through this quickly too. It's an interesting case. This was back in the day when they were just installing Wi-Fi at schools. This was at LAUSD. And a teacher said, I'm not comfortable having Wi-Fi. I don't think it's going to be safe. So the district did exactly what it's supposed to do. It talked to her about it, engaged her in the interactive process. She got something from a doctor. They said, okay, we're going to turn off the Wi-Fi in your room and the rooms around you. But then she said she still had problems. She came to work. She complained of chronic pain, headaches, other things. They engaged her in the interactive process again. This was, by the way, years later. She came back. She said, you know what I want now? I want my walls painted with a certain kind of paint that'll keep the electromagnetic pulses or whatever they are out of my room. And LAUSD said, look, it's been years now. There's been studies on this. Wi-Fi is safe. So we're not going to engage you in this process anymore. And she sued, and she won. And can anybody identify where the district went wrong? I said it. I may have said it too quickly. I may not have emphasized it enough. But it's really important because disability interactive process things, they come up all the time. And how it's handled is so important. It's highly procedural. It's not intuitive. Okay, so somebody said they didn't engage in the process. So here, that's basically the right answer. So what happened was LAUSD took the position, Wi-Fi is safe. We know it's safe. There have been studies that it's safe. We're now done with the process because we know it's safe. The court said, That's not the standard. It's not the standard that it's safe. The standard is whether she can be reasonably accommodated. It's still having an effect on her. She still has notes from her doctor describing this. Can she be reasonably accommodated? Maybe she can, maybe she can't. But you don't just get to say, oh, it's safe, we're done. And there are a lot of lawsuits involving disability interactive process that really focus in on the process, not whether the person can be accommodated or not, but on the process. Here's, to me, a huge takeaway from this. You may or may not agree with me, which is fine. I think this actually goes to what you need to be doing for next year. I'm getting a lot of calls from schools who are saying, you know what our teachers are saying? Our teachers are saying, hey, we kind of dig this working at home. I think I can teach my class online next year. Why do I have to go back? Things have been going fine. Some schools, by the way, have been okay with it, at least in the short term. But here's the thing. If you expect your teachers to be back at school, in class, in person, what can you do to make sure that happens when, in my view, inevitably, a teacher will say, I'm disabled, I can't come back, but you know what? I can do it online. You need to have updated job descriptions. You need to have job descriptions that say an essential function of your job is reporting to work in person to teach your classes while you're there. Now, you're going to have to be able to substantiate that. I can think of a lot of reasons why that would be the case. But that's really important because job descriptions are often exhibit A in these kinds of claims. And my experience with schools is that job descriptions, if they exist at all, and most of the time they don't exist at all, if they exist at all, they're from like the 70s. They talk about disco, Donna Summer, and whatever. So you don't want that. You need to have it updated, and you should be working on that now. It's really important. Okay, this is the last polling question. Does a school have a duty to protect their employees from harassment by third parties? One more second. So it's okay turnout, although everybody seems to be going with the same answer. Okay, I'm going to end it. So 90% of people said yes. And the answer is yes. You do have an obligation to protect your employees from third-party harassment. Interestingly, at least to me, that didn't always used to be the case. Disco was the 80s. Sorry about that. That didn't always used to be the case. But the legislature changed the law, and you absolutely have a duty to protect yourself from, protect employees from third parties. Now, in the school context, too often, I'm sorry to say, that's parents. It's parents who are upset with teachers and say things based on a protected category, or who think they're being funny, or whatever it is. But you have to take that seriously. You have to stop to it. This is a case that really just makes that point. The facts are simply that this was an employee who worked at a bank. There was somebody who had an account at the bank who would go to this teller a lot, would pass her notes a lot, would bring her flowers, then started showing up at places outside of work. She said, you need to stop this. The bank didn't take sufficient action, told her, well, just leave him alone, just go to the break room. That's not enough. And she sued and she won. So if you have complaints about third parties, whether it's a parent or the UPS person or whoever it is, you have an obligation to take those seriously and do what you can to put a stop to it. Okay, discrimination, always an issue. This is a case where the school was saved by documentation. I'll just tell you very briefly, this was an employee who was 73 years old. My favorite fact about her, you're going to think this may be sexist and genderist or something else on my part. 73 years old. One of the complaints they had about her was that at her locker, she kept a picture of a male model with his shirt unbuttoned down his chest. I don't know. She's 73. I personally, I don't think I'd really hold that against her, but they did. They didn't like that. Anyway, they ended up letting her go for other misconduct, but including that image. And she sued for age discrimination. And she said, look, you know what's evidence of age discrimination? I had a birthday party and somebody said to me, oh, I didn't know that you were that old. And somebody else said to her, oh, I don't know why they always say oh before they speak, but in this case they said, oh, how come you haven't retired yet? And she said that's evidence of age discrimination. And the court said, you know what, that could be evidence of age discrimination. So you do have to be careful, by the way, because really that could be evidence of age discrimination. But there were two important facts here. One was that the people who made the comments were not the people who decided to terminate it. The court said it's sort of irrelevant in this case. The other thing the court noted, which was kind of a relief to me, was that that's kind of the thing people would say at a birthday party for a 73-year-old. Like, it's just not necessarily age discrimination. I mean, honestly, from my viewpoint as a lawyer, would I want them to say it? No. Because then there's a lawsuit and there's a claim, you got to defend it. But at least the court understood that in that context, it wasn't really age discrimination. Okay, any questions about that? All right, equal pay. So I do want to talk about equal pay for one moment. You may be aware of it, you may not, so I just sort of want to set the table for a second, which is that there's both federal and state law that have to do with ensuring equal pay for men and women. But that doesn't mean that all men and women have to be paid the same. It means men and women have to be paid the same for doing the same kind of work. And that's often where the debate lies. You could say we have one teacher who's a woman, one teacher who's a man, by the way, because not only men getting paid more and women not, it can be the opposite too, either way. And, you know, why is this person getting paid more? Because they have more experience, they've shown more initiative, they have better performance. In other words, you can distinguish it. I've been a little bit surprised to discover that one area where there's been a lot of litigation on this over the years has to do with coaches, with male coaches being paid more than female coaches, and colleges and universities primarily, but also schools, having to try to explain to a court why it is the male coaches who are coaching boys basketball and football and whatever are making more than female coaches who are doing women's basketball and volleyball and other things like that. It's been litigated more than you may think, and I'm seeing it turn up more often than I have in the past when there's claims. So I just want you to be aware of it. Also, as you can see, the Department of Labor brought claims against Princeton in this regard, and Princeton ultimately had to settle. Now, in the settlement, they didn't admit any wrongdoing, because nobody ever does where there's a settlement. But the fact that they had to settle might mean that there was something that caused them a problem. So why am I telling this to you? Because of all the cases that we've talked about, of everything I've covered, this case is one where you can solve this problem before you have a problem. You can do an audit of your payroll. You can create 2 columns. By the way, I'm really bad with math, so 2 columns is already a challenge for me. But if you have 1 column of men, 1 column of women in the same kinds of jobs, right? You can figure out how you're going to do that. English teachers, science teachers, however you want to do it, coaches. And you just see, is there a disparity? And if there is a disparity, are you confident you can explain that disparity based on legitimate factors? that's something you can do now. That's something you should be doing now. And if you see that there's a problem, if you see there's something you can't explain, you can fix it. And maybe you can't fix it overnight, but maybe you could fix it over the course of a couple of months or a year. You can do something to lower your potential liability. This issue is one, also, by the way, it's not just a legal issue, it's a societal issue. And it's one that I think is positive, candidly. There's been a lot of movement to create greater equity based on gender. That's why, as you probably all know, there's restrictions on what you can ask people in job interviews now about wages, and it's a way to try to stop this inequity in wages from continuing. It's the kind of issue, by the way, that makes a good article. And you don't want to have that article written about your school. So this summer, I think on your to-do list should be, looking at this, trying to make sure you're in a good spot. Okay, any questions about equal pay? All right, we only have a couple of minutes left. I'm going to just talk about a few bits of litigation, but in absolutely no detail. If people want to type in questions, I'm happy to answer them. By the way, if you have questions you didn't raise, you could always ask me separately, and I would be happy to address them. The cases mandated reporting, there's been changes to mandated reporting laws over the last few years. This extends who's covered by it. I wanted to mention there's requirements on training on mandated reporting. Everybody who you hire who's a mandated reporter has to sign something saying they understand they have that duty, that obligation. You put that in their file that has to be there permanently. So you have an obligation to do that. COVID, I don't think we've seen the end of how the country, how the state, by the way, how different counties, sometimes cities, are trying to deal with COVID, trying to deal with job issues, trying to deal with people needing time off. No exception. Here, you're probably aware of that. We have a lot of special bulletins on this already. And then, I think this is COVID related in some ways. Some of you may disagree, but Family Rights Act has been extended too, to give people more time off. And I think in part, I would go out on a limb and say, that's because there was such strain put on people during the pandemic, and still needing to be at home, needing time off for childcare and other things for people who are sick. So we're seeing that in the legislation now, and I don't think we're done with it. Okay, I'm right on time. That never happens. It's 4:44. People have questions, please let me know. I don't know if Martha, Andrea, anybody wants to chime in the seconds that we have left, but I really appreciate it. I appreciate everybody being here, participating. I've enjoyed it maybe more than anybody else who's here.
Michael, thank you so much. I mean, how often do we get a legal presentation that references Borat and Sacha Baron Cohen? To answer Tony's question, I think that they live in England, but I'm not positive, so I don't think we have an in. But it's a really good reminder that there continue to be a lot of other things going on besides COVID, that COVID oftentimes also highlights things that existed before and makes us think about them in a new way. So this is always very helpful. Thank you to everybody for attending the conference. Thank you, Michael, for presenting at our conference. We look forward to hopefully having a conference next year in person in Los Angeles. So that's the goal. We have the hotel, we're ready. And in the meantime, please, if you have a topic that you'd like to discuss, or if there's something that you'd like to know more about, please feel free to reach out, and we will look into it, and we'll continue to stay in touch over Zoom until we can see you in person. So thank you.
All right, thank you. All right.